Mr. Chairman, and committee, I appreciate the opportunity to testify before the Sunset Advisory Commission, and I'm testifying this morning first to address the issues involving the Texas Board of Architectural Examiners, and later today to address the issues involving the Texas Board of Professional Engineers. I am a licensed professional engineer. You should have a copy of my report, which combines the two hearings, and the relevant portions of my...
Do you want to come back for the engineer's part, or if you like, you can do it all now? What were you planning to do? Were you going to do two separate?
I was going to do two separate
I'm not going to
hearings.
make you do it all now, but you might find yourself sitting here a while to do the next. So it's up to you.
I don't mind. I've got work in my briefcase.
We're going to let him take both areas. So I apologize to interrupt you, but
right.
You might thank me later when you are
right.
home and we're still here.
Okay. Let me start then with the architects. The relevant portions of what I want to talk about are in my report on page 45. I hope you all have a copy, but if you don't, it'll be furnished online with the exhibits at www.amstarengineeringinc.com later on this week. I'm president of the company. I want to preface my comments relating to the architects by stating the major problems concerning violations of law stated in my report are occurring at the Texas Board of Professional Engineers and not, to my knowledge, at the Texas Board of Architectural Examiners. I received a Bachelor of Science degree in Architectural Engineering in 1965 and a Master of Science degree in 1966 in Architectural Engineering, both degrees from the University of Texas. I took the licensing exams to become a professional engineer, and I became licensed in 1970. Before and at the time of my licensure, I was assured by state officials that I could practice both engineering and architecture with an engineering license insofar as I had the educational experience requirements involving both engineering and architecture. I was told I could not, however, practice engineering unless I took and passed both the EIT and the engineering practices exam. I took both exams and I passed both exams. I have spent my entire career designing all manner of engineering and architectural projects, including designing buildings of all types, including providing the specifications that would be considered both engineering and architectural in nature. I've never held myself out as a licensed architect. Beginning in the late 1970s, I taught seminars for the architect registration exam candidates. I have also taught on video the principles of the Americans with Disabilities Act. At the end of last year, I made application to the Architectural Agency to continue my decades-long building design practice as a professional engineer in accordance with the conditions stipulated in the two-board agreement involving both the Architectural Board and the Engineering Board that was passed into law about a year ago by the previous legislature. My application was denied. The agency agreement does not work. My constitutional rights to practice my profession in Texas have been violated. The state of Texas has made a mistake of denying architectural engineers the ability to carry on their profession with the recent enactment of a law that limits the ability of engineers to design buildings. I'm hopeful that an effort will be made during the upcoming legislative session to rescind the recently passed legislation that prohibits professional engineers from designing buildings, including architectural engineers like me who have practiced a lifetime in their chosen profession. However, if no effort is made to undo the recent legislation, then I will have no other choice other than to file a lawsuit. And since the Texas Board of Architectural Examiners is operating under semi-directed, semi-independent, or SDI status, I believe that I could be awarded financial damages in excesses of the amount limited by sovereign immunity. However, money is not my goal here. My goal is to try to help facilitate a reasonable solution to the problem. I will speak further about the impact of SDSI status when I talk about the Board of Engineers. In searching the Occupations Code governing architects, Title VI, Subtitle B, Regulation of Architecture and Related Practices, Chapter 1051, Texas Board of Architectural Examiners, use of the term protect the health, safety, and welfare of the general public found in the Engineering Practice Act is not to be found anywhere within the body of regulations governing the practice of architecture. The Texas Supreme Court has recently heard a case involving a licensed architect. The architect had designed a house, and the house had a wood balcony attached to the rear part of the house. The balcony was several feet from the ground. The architect had provided a detail that showed that the balcony was to be connected to the house with bolts. The architect also had a contract to inspect the project during construction. The contractor substituted nails for bolts. The architect inspected the project. The substitution of nails for bolts was open and obvious, but the architect did not observe that the substitution had been made. After the house was completed and occupied, a visitor of the house stepped out on the door onto the deck. The deck collapsed, critically injuring the woman, who remains paralyzed. A jury trial found against the contractor with a small portion of the blame attributed to the architect. The architect appealed. He argued that although he had a duty to the owners of the house that he had designed, he had no duty to visitors to the home. The court determined the injured visitor requested, quote, this court to transform and extend the contractual duty owed to the homeowner into a common law duty owed to, unquote, the injured visitor. Now, I'm not a lawyer, and I simply found this case in the newspaper. It appears to me, and it came out, this article came out in the Austin American-Statesman on September 1st of this year. It appears to me that the Texas Supreme Court is saying that licensed architects are no longer required to practice the health, safety, and welfare of the general public, leaving the obligation to the professional engineers. One last thing I want to mention on this subject is the state of Mississippi has observed what has happened in Texas regarding this act preventing engineers from designing buildings. In June of this year, the Mississippi Attorney General issued an opinion dated June 29, 2012, that engineers who engage in building design can do building design without hindrance from that state's boards of architects. I hope you'll read my report. It's the short part of the report. And if you want me to go ahead and testify as to what's going on at the Board of Engineers, I'll continue.
How much time is it? What, 1 minute left? You got 1 minute?
1 minute on the engineers?
You got a total of 6 minutes, or both.
All right, well, what I'll do then, wait a second.
Just tell us, don't read it, tell us.
And you've got a lot of written testimony, and that goes in the record.
All right, I'll just tell you.
That'd be nice.
The engineering board is totally out of control. I am seeing all kinds, it's really nothing more than another builder protection agency like the TRCC. I am seeing major problems in court appearances and the mandates by the Board of Engineers to design foundations in a manner that is known to be substandard by 98% of the engineers in this state. But the board will discipline engineers who design it unless they design it in a manner that keeps foundations cheap. And that's one part of the problem. We have as early as 1999, when the Aggie bonfire collapse occurred, you got instances of a cover-up, which is now documented and taking place between the Board of Engineers and Texas A&M. You have criminal activity, sir, taking place in the Board of Engineers. I've already reported it to the Travis County District Attorney, and I'm telling you as a legislator, as a representative of the legislature, the SDSI status has opened the Pandora's box for lawsuits left and right by all people who have been defrauded by the Board of Engineers. I hope you read my report.
Pretty strong charge.
Senator Nichols has a question.
Yes,
question. In your earlier statement regarding architects, because you said you had an architect degree as well.
No, I have an architectural engineering degree. I have a bachelor's.
But you said in the architectural code, I thought you said that in the engineering code, health, safety, and welfare is in there. In the architectural code, it is not.
That's correct.
It's not in there.
Couldn't find it.
So you're recommending it should be in there?
Yes.
Okay. Second thing was your comments on the architect actually doing the inspections on the construction project that he or she designed. It was my understanding it was a contract between the builder and the architect on whether or not they would inspect or they would not inspect. In other words, I've built a lot of projects, and if I wanna pay the architect extra, it's just part of the contract, I want you out there on the site checking to make sure they did it the way you designed it, or not.
My understanding in that particular case was that the agreement was between it was a custom home, as I understand it, and the house, the architect had an agreement to conduct on-site inspections during construction.
Okay, and they didn't do it properly, so.
And they didn't do it
they were
properly.
liable. Okay, thanks.
You were talking about a specific situation. You were talking about a specific situation.
In that
Not a
particular
general.
case. In that particular case.
Correct.
And like I said, I'm not a lawyer,
Right.
but the newspaper article would lead one to believe that, that the court has basically said architects do not have to be responsible for the health, safety, and welfare of the general public.
Right, okay, thank you very much.
Okay.
Paul LeBrant, David Vanover, Kelly Barnett, Grace